back to the channel EduTap. I am Arshdeep Kaur and I am back again with another video on CPC. We have already done 2 videos on CPC. We have done 2 lectures and today is our 3rd lecture. Right? So before starting, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. For your revision, it is going to be very helpful. It will include the chapter-wise tests, sectional tests and full-length tests. And we have also come up with a live crash course. The live classes, they are already going on and it is for both the phases, phase 1 and phase 2. It includes the live classes, the test series I just mentioned, and you also get one-on-one mentor support. We will be dealing with all the subjects that are mentioned in your syllabus, but primarily we are focusing on the security laws and the company's laws, right? So they are very important for your examinations. So if anyone who is interested can refer to the link in the description below. Now let's start with the lecture. Question number 1. Under Order 7, Rule 11 of the Code, the plaint shall not be rejected where it discloses cause of action, where it is not filed in duplicate, where the suit appears from the statement in the plaint to be barred by law, where the plaintiff fails to comply with the provisions of Rule 9, or where the relief claimed is undervalued. So the answer is option A, where it discloses a cause of action. Let's read this rule. What is this rule talking about? It says rejection of plaint, right? So the title is rejection of plaint. A rejection of plaint does not operate as a res judicata because it has not been decided on merits, right? This I've told you that in res judicata, a res judicata only applies where the previous suit is decided on merits, right? Where it is conclusively decided. But if a plaint is rejected, it is not decided on merits, right? If we read Rule 13, it says that rejection of plaint does not preclude the plaintiff from filing a fresh plaint with the same cause of action. So it does not operate as res judicata because it has not been decided on merits. It is not conclusively decided between the parties, right? So now rejection of plaint, the plaint shall be rejected in the following cases. This list, it is not exhaustive. There can be many more reasons where a plaint is rejected. Like according to the Supreme Court, if the plaint has been signed by a person who is not authorized, in that case also it can be rejected. Or if it is a premature suit, right? In that case also it can be rejected. So this list that we are reading, that we are going to read, this list is not exhaustive and there can be many more examples where a plaint can be rejected. First one, where it does not disclose a cause of action. So the word used here is disclose. They are not saying that there is no cause of action. They are saying that you have not disclosed that what the cause of action is. In that case, your plaint is liable to be rejected. For example, there was a suit which kept on saying that a fraud has been committed, but it did not disclose what was that fraud, right? In that case, it was rejected. So that is why they are saying where it does not disclose a cause of action. Where the relief claimed is undervalued, where they have wrongly mentioned, they have undervalued the claim. So where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so. First of all, it was undervalued. Then the court gave time to that party to correct it, and it did not correct it even after that time was given, right? So in that case, it is going to be rejected. So where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so. Where the relief claimed is properly valued, now they are talking about the situation where they have properly valued the claim, but the plaint is returned upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so. But now the papers, they were insufficiently stamped, and the court had given time to correct it as well, but it fails to do so, right? So where the relief claimed is properly valued, but the plaint is returned upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so. where the suit appears from the statement in the plaint to be barred by law. If in any case it is barred by law, then also it is going to be rejected. Where it is not filed in duplicate, where the plaintiff fails to comply with the provisions of Rule 9, provided that the time fixed by the court for the correction of the valuation or supplying of the requisite stamp paper shall not be extended. So it shall not be extended. This is the journal rule, but there is an exception. Unless the court for the reasons to be recorded is satisfied that the plaintiff was prevented by a cause of exceptional nature. So if the court is satisfied that the plaintiff, he was prevented by a cause that was exceptional in nature from correcting the valuation or supplying the requisite stamp paper, as the case may be, within the time fixed by the court, that the refusal to extend such time would cause grave injustice to the plaintiff, right? In that case, they are going to extend the time. Now let's read it. Provided that the time fixed by the court for the correction of the valuation or supplying of the requisite stamp paper shall not be extended unless the court for the reasons to be recorded is satisfied that the plaintiff was prevented by any cause of exceptional nature from correcting the valuation or supplying the requisite stamp paper, or as the case may be, within the time fixed by the court, and that the refusal to extend such time would cause grave injustice to the plaintiff. I hope this section is clear to you. Question number 2. A defendant under Order 5, Rule 1 of CPC is required to appear, answer the claim and to file the written statement. It has to be filed within 30 days from the date of service of summons. Let's read it. When a suit has been duly instituted, I've told you what does it mean by duly instituted. A summons may be issued to the defendant. So a summons has to be issued to the defendant to appear and answer to the claim. So he has to appear and he has to come and answer the claim, and he also has to file the written statement. Written statement is his reply to the plaint, right? So he has to file that written statement of his defense, if any, within 30 days from the date of service of the summons on the defendant. So from 30 days, he has been given the time period of 30 days from the date he receives such summons, right? Provided that no such summons shall be issued when a defendant has appeared at the presentation of a plaint and admitted to the plaintiff's claim. In case the defendant has come when the plaint was being presented before the court, in that case the summons shall not be issued, right? So provided that no such summons shall be issued when a defendant has appeared at the presentation of the plaint and admitted the plaintiff's claims. And in case that he has already admitted to the claims of the plaintiff, in that case the summons, they shall not be issued. Provided further that where the defendant fails to file the written statement within the set period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for the reasons to be recorded in writing and on payment of such cost and the courts deem fit. So if he fails to file that written statement within 30 days, he shall be allowed to file it again within a specified time period that the court gives him, right? And the court shall record the reasons in writing and also impose any cost on that defendant if the court deems fit, but which shall not be later than 120 days from the date of service of the summons. But that time period, it cannot extend 120 days from the date of the summons that were issued to him, right? So, but shall not be later than 120 days from the date of service of the summons, and on expiry of 120 days from the date of service of the summons, the defendant shall forfeit the right to file the written statement, and the court shall not allow the written statement to be recorded. In case 120 days have passed and the written statement has not been filed by the defendant, in that case his right to file the written statement, it is forfeited, right? And in that case the court shall not allow the written statement to be filed again. So he will not be given more than 120 days in case he has not filed his written statement within that period, right? Question number 3. Summons to the defendants under Order 5, Rule 9(1) of the CPC can be delivered for the purpose of serving the same on the defendant to the courier service as approved by the defendant, approved by the court, or approved by the plaintiff. So the answer to this question is option C. Let's read it. What does it say? Where the defendant resides within the jurisdiction of a court in which the suit is instituted, or has an agent resident with the jurisdiction who is empowered to accept the service of the summons shall, unless the court otherwise directs, it will be delivered or sent either to the proper officer to be served by him. It can be hand delivered by a proper officer of the court, or one of his subordinate or subordinate to that officer, or such courier service as are approved by the court, or such other courier service that has been given approval by the court. They can deliver it, right? Let's read this again. So, where the defendant resides within a jurisdiction of the court in which the suit is instituted, or has an agent resident with the jurisdiction, or is empowered to accept the service of the summon shall, unless the court otherwise directs, be delivered or sent either by a proper officer to be served by him, or one of his subordinates, or to such courier service as are approved by the court. Question number 4. Under Order 6, Rule 17, at any stage of proceedings, the court can allow to alter or amend the proceedings to. The answer is A, that is either party. This forms an important question. So it is what? It is either party. Let's read amendment of pleadings. What does it say? The court may at any stage of the proceedings allow. So it can be during any stage of proceedings. It has to be during proceedings. They are not talking about the trial. They are talking about the proceedings, right? So at any stage, so the court may at any stage of the proceedings allow either party, and they can be allowed to both. Either party here means that you can amend your plaint also and your written statement as well. So the court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner as on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. If the court thinks fit, that it can allow for such amendment, right? Provided that no application for the amendment shall be allowed after the trial has commenced. But it shall not be allowed once the trial has commenced, right? It can be allowed when the proceeding is going on, but it cannot be allowed when the trial is going on, right? So provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. But if the court thinks that the parties could not have raised this question when the proceedings were going on, when the trial commenced, then in that case, the court can allow the amendment at a later stage as well, right? So provided that no application for the amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the parties could not have raised the matter before the commencement of trial. Pleadings, what is pleading? So pleading shall mean the plaint or written statement. I hope everybody knows this. Question number 5. Which of the following deals with the procedure when the party fails to present written statement called for by the court in the Code of Civil Procedure? The answer is Order 8, Rule 10. So where any party from whom a written statement is required under Rule 1 or Rule 9 fails to present the same within the time permitted or fixed by the court, as the case may be, the court shall pronounce judgment against him. So in that case, the court is going to do what? The court is going to pronounce a judgment that will be against him, right? So shall pronounce judgment against him or make such order in relaxation to the suit as it thinks fit. Or it can also do what? It can allow the relaxation of that time period. And on the pronouncement of such judgment, a decree shall be drawn up. Provided further that no court shall make an appeal to extend the time period under Rule 1. So they have to follow the provisions of Rule 1, right? So Rule 1 on this order for filing the written statement. Question number 6. A lets a house to be at a yearly of rent rupees 1200. The rent for the whole of the years 1905, 1906 and 7 is due and unpaid. A sues B in 1908 only for the rent due in 1906. So A, now in this case, he shall not be afterwards allowed to sue B for the rents that are due to him in the year 1905 and 1906. Right, let's read this rule, what this rule is saying. So every suit shall include the whole of the claim. So the suit that you are filing, it shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action. but a plaintiff may relinquish. Relinquish means it intentionally giving up, right? So he can intentionally give up and portion. Portion means to reduce, right? So and portion of his claim in order to bring the suit within the jurisdiction of the court. Second, where a plaintiff omits. Omits means that he forgets, right? So where he omits to sue in respect of or intentionally relinquishes, or he is intentionally giving up that claim, any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. So if he gives up the whole claim or any portion of it, or if he even forgets about it, if he even omits to file that claim, right, in that case he will not be allowed to file another suit for that claim that he omitted, right? So what they are talking about is that where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. A person entitled to more than one relief in respect of the same cause of action may sue for all or any of such relief. But if he omits, except with the leave of court, not with the leave of court, but otherwise to sue for all such reliefs, he shall not afterwards sue for any relief so omitted. So if he is omitting where he was liable to receive 2 or 3 reliefs and he is only asking for one, in that case he shall not be allowed to file another case for the remaining 2 reliefs, right? So a person entitled to more than one relief in respect of the same cause of action may sue for all or any of such reliefs, but if he omits, except with the leave of court, to sue for all such reliefs, he shall not afterwards sue for the relief he has omitted. For the purpose of this rule, an obligation and a collateral security for its performance and successive claims arising under the same obligation shall be deemed respectively to constitute but one cause of action. So they are saying that if, for example, your relief had successive reliefs as well, so in that case you have to file your successive reliefs also in that suit only. So for example, you are asking for one relief and out of that relief successive or collateral reliefs also come. For example, you are liable to receive mean profit or you are liable to receive interest. In that case you have to file all these in one suit only, right? So for the purpose of this rule, an obligation and collateral security for its performance and successive claim arising under the same obligation shall be deemed respectively to constitute but one cause of action. A lets a house to B at yearly of rent of 1200. The rent for the whole of the year 1905, 6 and 7 is due and unpaid. A sues B in 1908 only for the rent in 1906. A shall not afterwards sue B for the rent due for 1905 and 1907. So in this illustration, he was supposed to file the suit with respect to all these years, right? The year of 1905, 6 and 7. Now that he has missed and he has not filed for 1905 and 7, now he cannot file another suit and claim the rent of these years, right? I hope this section is clear to you. Question number 7. A defendant to whom a summon has been issued under sub-rule 1 of rule 1 of order 5 may appear. So the answer is B, that is all of these are correct. Let's straight away go to the rule. A defendant to whom a summon has been issued under sub-rule 1 may appear. He may appear in person or by a pleader duly instructed and able to answer all the material questions relating to the suit. Or his pleader can also appear in his behalf and who is instructed properly and he has all that information that is required. By a pleader accompanied by some person able to answer all such questions, or the pleader can accompany any such person who can answer all the questions on his behalf, right? So he can appear in person by any pleader duly instructed and able to answer all the material questions relating to the suit, or by a pleader accompanied by some person able to answer all such questions. Question number 8. Which of these statements is incorrect? Pleadings shall mean plain or written statement. Every pleading shall, when necessary, be divided into paragraphs numbered consecutively, each allegation being so far as is convenient contained in separate paragraphs. Dates, sums and numbers cannot be expressed in a pleading in words. Every pleading shall contain only a statement in concise form for all the material facts on which the party pleading relieves for his claim or defense as the case may be, but not the evidence by which they are to be proved. So the answer is option C. The C is incorrect. And what is the correct statement? Let's read it. Order 6 lays down the rules for pleadings in general. Rule 2.3 states that dates, sums and numbers, they shall be expressed in the pleadings in figures as well as in words. Question number 9. Which of the following statements is correct with respect to Order 11, which deals with the discovery and inspection? Interrogatories shall be in form number 2 in Appendix C with such variations as circumstances may require. Interrogatories shall be answered by affidavit to be filed within 10 days or within such other period as the court may allow. An affidavit in answer to the interrogatories shall be in Form 3 in Appendix C with such variations as circumstances may require. In any suit, only the plaintiff by leave of the court may deliver interrogatories in writing for the examination of the defendant. The answer is option C, that is first, second and third statement. They are correct, but the fourth one is not correct. Let's read the fourth statement. The correct statement is Rule 1 states that in any suit, the plaintiff or the defendant by the leave of the court may deliver the interrogatories in writing for the examination of the opposite party. So the interrogatories, they can be delivered by both the plaintiff or the defendant, right? Examination of the opposite party or any one or more of such parties, and such interrogatories when delivered shall have a note at the foot thereof stating that which of the interrogatories each person is required to answer. Now, what do you mean by interrogatories? Interrogatories are nothing but a set of questions. They are just a questionnaire that one party delivers to another party that they have to answer. It is for the discovery of fact, right? So in a case, one party feels that the opposite party is hiding something or is withholding to some fact, right? In that case, they can prepare a questionnaire, they can prepare a set of questions and they can deliver to the opposite party with the leave of the court, of course, and they can ask the opposite party to answer these questions. So this is what interrogatories mean. And the interrogatories, they are under oath, right? So they have to be answered under oath. So all of these statements, they were correct. Only the statement fourth was incorrect. They can be delivered by both the plaintiff and the defendant, right? I hope you have understood that what are interrogatories. Moving on, question number 10. Which of the following statement is incorrect? Where it appears to the court that any joinder of plaintiff may embarrass or delay the trial of the suit, the court may put the plaintiffs to their election or order separate trial or make such other order as may be expedient. Where it appears to the court that any joinder of the defendant may embarrass or delay the trial of the suit, the court cannot order separate trial or make such order as may be expedient in the interest of justice. It shall not be necessary that every defendant shall be entrusted as to all the reliefs claimed in any suit against him. No suit shall be defeated by the reason of misjoinder or non-joinder of the parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and the interest of the parties actually before it. So the answer is option B, that the B statement is incorrect. Let's read what is the right statement. Where it appears to the court that any joinder of the defendant may embarrass or delay the trial to the suit, the court may order separate trial or make such other order as may be expedient in the interest of justice. I hope this is clear to you. Now, the question for achievers. A deposits a box of jewel with B as his agent. He then writes to C for the purpose of making the jewels a security for a debt due from himself to C. A afterwards alleges that C debt is satisfied and C alleges the contrary. Both claim the jewels from B. Now, B cannot institute a interpleader suit against A and C. B may institute an interpleader suit against A and C. B may institute an interpleader suit against A only. B may institute an interpleader suit against C only. So we have discussed that what are interpleader suit in our previous video. So you have to comment the right answer below. That was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.